Good morning, everyone. Welcome to the Federal Trade Commission and the first day of our hearing on the FTC's approach to consumer privacy. My name is Jim Trilling. I am an attorney in the FTC's Division of Privacy and Identity Protection. Before we get started with the substance of the hearing, I have a number of brief administrative announcements that will apply throughout the hearing. First, if you leave the Constitution Center building during the hearing, you will need to go back through security screening again, so please allocate time for that. Restrooms are located outside of the auditorium in the hallway, and the Constitution Center building cafeteria is located around the corner on this floor of the building. If an emergency requires you to leave the auditorium but remain in the building, please follow the instructions that will be provided over the building's PA system. If an emergency requires evacuation of the building, an alarm will sound. Please leave the building in an orderly manner through the 7th Street exit. When you get outside, turn left and proceed down 7th Street and across East Street to the FTC emergency assembly area and remain in that area for instructions to return to the building or otherwise. If you notice any suspicious activity, please alert the building security staff. This hearing is being photographed, webcast, and recorded. By participating in the hearing, you are agreeing that your image and anything that you say or submit may be posted indefinitely at ftc.gov, on regulations.gov, or on one of the Commission's publicly available social media sites. The webcast recording and transcripts of the hearing will be available on the FTC's website shortly after the hearing concludes. Webcast recordings and transcripts from all of the FTC hearings on competition and consumer protection are available on the FTC website. Audio files from the hearings are available to be streamed or downloaded at ftc.gov/audio. Please silence your cell phones and other devices. We want to make sure that everybody has the ability to be heard. Attempts to address the hearing speakers while this hearing is in progress and other actions that interfere or attempt to interfere with the conduct of this hearing or the audience's ability to observe the hearing are not permitted. Any persons engaging in such behavior will be asked to leave. Anyone who refuses to leave voluntarily will be escorted from the building. During the panels, the audience is invited to submit questions via question cards that are available from FTC staff and in the hallway outside the auditorium. If you would like to submit a question, please write the question on a card and raise your hand to signal for FTC staff to collect the question from you. FTC commissioners and staff are unable to accept documents during the hearing. Such documents will not become part of the official record of any commission proceeding or be considered by the commission. We do invite the public to submit written comments for the hearing. You can submit comments online via the link on the FTC website until May 31st. If you received a visitor's badge today, please return it to the security staff on your way out of the building so that we can reuse it. With those logistics out of the way, we can now move on to the substance of the hearing. I am pleased to turn the podium over to FTC Chairman Joseph Simons for opening remarks.
Well, good morning, everyone, and welcome to our two-day hearing on the FTC's approach to consumer privacy. We are so excited for this event. Over the past few years, we have seen technology develop that was nearly unimaginable only a few decades ago. Tiny computers sit in our pockets and funnel news, messages, and more our way. Smart speakers do our bidding. Other smart devices unlock our doors, set our thermostats, and turn out the lights. Robots powered by artificial intelligence are becoming commonplace on factory floors, and self-driving cars are on the streets of Pittsburgh, Boston, Las Vegas, and San Francisco. What unifies these remarkable inventions is what fuels them: data. We live in an age of truly amazing technological changes powered by data. But along with the enormous benefits of data-driven innovations comes a certain degree of risk. News stories highlight troubling privacy practices on a regular basis, whether it's allegations of surreptitious recording by Internet of Things devices, inadvertent exposure of health information, or the sharing of personal data beyond consumers' authorization. Have we become inured to these privacy incidents? Not at all. In the face of these disclosures, consumers report that they do care about their privacy and that they value the ability to control what information is collected about them and who can get that data. These concerns arise from the recognition that privacy violations can cause a range of real harms, including fraudulent charges on credit cards, safety risks, reputational injury, and unwanted intrusion into people's homes and the intimate details of their lives. And ultimately, that's why we are here today. Together with the public comment process that we started last summer, this hearing marks one of the Commission's most extensive efforts to engage the public on data privacy issues since the Commission issued its comprehensive privacy report in 2012. These hearings are part of a greater effort by the FTC to stay abreast of new and emerging technologies as they rapidly evolve. The FTC has long been the cop on this particular beat. Over the past 2 decades, we've brought hundreds of cases, conducted over 70 workshops, and issued about 50 reports to help protect consumers' privacy. Our work over the last year demonstrates the FTC's approach to consumer privacy, vigorous enforcement with every tool that we have. For example, in February, we announced a settlement that includes the largest civil penalty the Commission has ever obtained under Ccpa. Last fall, we obtained a $3 million civil penalty under the FCRA against a company whose automated decision-making tool provided inaccurate data to property managers, resulting in denial of housing. We've used our Section 5 authority to challenge false claims about compliance with the EU-US Privacy Shield and to stop purveyors of fake pay stubs that identity thieves use to get jobs and housing in other people's names. We've brought privacy cases against a revenge porn site, a mobile phone manufacturer, a peer-to-peer payment service, and an apps-based ride service. We've also filed 2 advocacy comments, announced 5 public events, issued a staff report on privacy injuries, and issued a notice of proposed rulemaking to help military personnel get free credit reports. As this list of accomplishments demonstrates, the FTC has done a remarkable job to protect consumers' privacy with the tools and the resources at our disposal. But we must do more. We need to continue evaluating privacy risks as they evolve. What approach will protect consumers' privacy interests while fostering innovation and competition that has brought us so many benefits? That brings us back to the agenda for this hearing. Over the next 2 days, you will hear from dozens of leading experts from government, academia, business, and policy shops who have thought deeply about these issues. Today, we begin with a conversation about the goals of privacy. What exactly are the harms that we are trying to address? And what are the countervailing considerations, like the effect on innovation and competition? We will then turn to the data risk spectrum. Panelists will evaluate what makes data sensitive, whether privacy protections should depend on such classifications, and how effective are techniques to de-identify that data. After lunch, we will hear from my colleague, Commissioner Phillips, who will share his thoughts about the Commission's privacy work. We will then discuss consumer demand and expectations for privacy, as well as whether and how companies respond or should respond to such demands. And we will round out today's session with a 2-part discussion about current approaches to privacy. Panelists will discuss, compare, and contrast U.S. and international privacy laws and self-regulatory frameworks. As policymakers consider privacy legislation, the panelists will consider what such a law might look like. Tomorrow, we will explore pros and cons of possible frameworks for protecting consumer privacy. The first panel will examine the role of notice and choice. Panelists will explore the various roles that notice and choice play in the current marketplace, as well as consider limitations on the effectiveness of notice and choice and offer ideas for addressing them. The second panel will analyze the role of access, deletion, and correction. Panelists will address the costs and benefits of providing these types of tools and will share their experience of how consumers use them. Commissioner Slaughter will provide her views about the FTC's privacy work, and then a panel will share views about what makes firms accountable for their privacy practices and whether policymakers should attempt to improve accountability from within organizations. Finally, two sets of panelists will discuss whether the FTC has an adequate toolkit for protecting consumer privacy, covering topics such as the use of our existing authorities as well as the need for new resources. We are excited to get this discussion started. But first, I want to thank the 50 panelists for participating in this event. We greatly appreciate your willingness to share your insights and your expertise. And I want to thank Jim Trilling, who you saw up here moments ago, his colleagues Alyssa Gilson and Jared Ho for leading the planning of this hearing. And I also want to thank my many other FTC colleagues from the Division of Privacy and Identity Protection, the Bureau of Consumer Protection more generally, the Bureau of Economics, the Office of Policy Planning, the Office of Public Affairs, and the Office of the Executive Director, who have worked so hard together to produce this event. Finally, thank you to everyone who is attending in person or watching online via our live webcast. We appreciate the opportunity to engage the public on this important topic, and I hope you enjoy the hearing. Have a great day.
Welcome. I'm James Cooper. I'm the Deputy Director for Economic Analysis in the Bureau of Consumer Protection. I'm happy to be here to have the first panel to kind of set the stage and bring us up to date to discuss some of the research and that we heard about back in the fall on the hearing on privacy, big data, and competition. Let me just give a brief introduction to the panel. I'm going to give kind of a brief presentation, but let me introduce the panel right now. We have Neil Chilson. Neil is the Senior Research Fellow for Technology and Innovation at the Charles Koch Institute. Before that, he was the Acting Chief Technologist under Acting Chairman Maureen Olhausen, and then an advisor for Acting Chairman Olhausen. And before that, he was a telecommunications lawyer at Wilkinson, Barker, and Nauer. Next to Neil is Alistair McTaggart. Alistair is the chairman of Californians for Consumer Privacy, and you all probably know him best for his leading role in the passage of California Bill 375, better known as the California Consumer Privacy Act. And finally, next to Alistair is Paul Ohm. Paul is a professor of law and the Associate Dean for Academic Affairs at Georgetown University Law Center. Paul is a leading scholar in information privacy, computer crime, intellectual property, all things digital, really. That's Paul. And also, he did a stint here at the FTC a few years ago as a senior policy advisor working on these very issues. So we have a great panel to discuss what Chairman Simon said, the goals of privacy protection. As we think through the issues on how best to protect privacy for consumers, it's important to maybe go back to some first principles and think about how that, to weigh, as Chairman Simon says, think about the benefits, what are we trying to do, and at the same time, think about some of the risks. So there we go. So when we think about really any regulation, any type of government intervention, we should ask a couple questions. The first is, what do consumers want? What is it that, what are their demands? The second thing, and I'm saying this as an economist, and I'm putting my economist hat on, the second thing that we should be interested in is, well, if there's something that consumers want, if there's a market, if there's some transaction that should be occurring, is it happening? Is the market able to mediate these demands, often referred to as a market failure? And that's bad for society. If there's a market failure, that means that there's some kind of welfare increasing transaction that is not occurring. So the third question we should ask is, well, if that's the case, is there something the government can do? Is there some sort of intervention that can make things better? Now, a market failure is a necessary condition, but it's not necessarily a sufficient condition because, again, as Chairman Simons discussed in his opening remarks, there are often risks and countervailing costs that come with any government intervention, and those always need to be considered. So moving from the more, from the general to the specific, let's drill down a little bit and talk about privacy, apply some of this framework to privacy. Okay, first, what do consumers want? Well, survey evidence suggests that privacy is very important to consumers. You see that in Pew polls, you see that in really any kind of, in popular press. Consumers really do care about their privacy. It's expressed a lot. But we also see revealed preference, which is when actual trades are made in the marketplace, when actual decisions are made, that there's a lot of evidence, both experimental and in the real world, to suggest that, well, consumers are willing to trade information about themselves for very small amounts. This is given rise, this is what is referred to in the privacy literature as the privacy paradox. And it's something that, at least in the academic world, that we try to square, that it is a paradox. Why do we see on one hand that privacy is clearly something that people care deeply about, but in the real world, they seem to make different trades? So next question is there some kind of market failure? Are consumers really getting the type of privacy protections that they want? So we said that revealed preference suggests that the consumers are willing to trade information for small amounts of money or convenience or access to content. Well, what are revealed preference a market outcome will correctly show consumer preferences, but markets don't always work. There could be failures like asymmetric information. The data ecosystem is notoriously complex. Do consumers really understand what's going on behind the scene? There are also cognitive biases. Alessandro Acquisti and a lot of his colleagues at Carnegie Mellon have done a lot of work in this area, but we all know that consumers from the behavioral economics literature suffer a variety of systematic errors, especially in being able to assess long-term benefits and costs. So we have those possible, we look at that. There's also market power. Maybe market power can sometimes be thought of as a market failure, depending on how a firm gained that market power. On the other side of that, we have to think, and we're asking whether there's a market failure, understanding is endogenous in the sense that what a concept in economics called rational ignorance, that gathering information is costly, and rational individuals will gather information up to the point where the marginal benefit of that information is equal to the marginal cost. When we go out into the marketplace, all the time, we don't always have perfect information of the distribution of prices, and I think we could all think about times where we've gone and bought something and found out, oh, I don't really like this, or I could have gotten it cheaper somewhere else, but that's rational. It's rational ignorance. We also know that there's a powerful incentive for firms to reveal good things about them relative to their competitors. It's this unraveling principle that if I can credibly show you that I, say, provide more privacy than my competing firms, then I have a really, really strong incentive to do that because I'll gather more customers. Also, we see in the context of behavioral economics that as stakes increase, there's at least experimental literature to suggest that as stakes increase, consumers tend to, the biases tend to wash out or become a little less pronounced. So it's unclear when we think about whether there's a market failure, there is evidence on both sides of this. And finally, when we think about on the benefits, we think about intervention. What should government do? Well, certainly the clear benefit from any privacy regulation is if there is a market failure, if there's something, if consumers really want a certain level of privacy and control over their information and it is not being provided to them, government intervention will help mediate that demand. So if the market isn't mediating the demand for control over information, well, government intervention can provide that and increase welfare. At the same time, there are costs. There's a large literature, both empirical and theoretical, that retarding information flows can have negative impacts on market performance and innovation, and we'll talk in a second about some of the research that was presented back in the fall at the hearings. And finally, when we think about what government should do, the form of intervention matters. Do we want to have an enforcement regime where we go after identifiable harms with law enforcement, take people to court, kind of in the way that the FTC acts now? And there's ex-ante regulation in the sense of commanding ahead of time what firms need to do. There's the FIPS model. There are lots of different regulatory models, and so the form that it takes really can have an impact on government intervention. So taking that framework and now moving, I want to go back to the fall and think of this as maybe on the last episode of the FTC privacy hearings, just as a recap to bring you up to date, to inform some of these questions that we need to think about when we think about the goals of privacy protection. So what have we heard? We heard, again, going to the privacy paradox, that even with full information, we have experimental evidence showing that consumers choose to reveal private information for very little compensation. We heard some work both from Leah Strahelovitz and Amri Ben-Shahar, some experimental work that they've done. At the same time, we also heard about work from Alessandro Acquisti and some of his co-authors and Catherine Tucker and Amalia Miller, that increasing trust can increase the willingness to share data that suggests that a lack of privacy protection, perhaps even in the healthcare area, can have some chilling effects. So we found out that when you give consumers control over the sharing of their data in genetic testing, that it suggests that it increases the willingness to engage in genetic testing. We also heard about research that increases in level that health information exchanges tend to perform better, or there tend to be more health information exchanges when there are consent requirements coupled with financial incentives. So what else have we heard? We think about the costs, and often privacy regulation, we think of opt-in versus opt-out. One of the big areas of potential costs is the revenue generated from targeted advertising. So what do we find? Well, there are a lot of research, we had a lot of experts at that hearing a lot of people who are expert on the online advertising ecosystem, and we heard that behavioral targeting tends to generate more revenue for content providers than contextual advertising. There seems to be a lot of empirical evidence to suggest that, but there needs to be some caution. First of all, there are strong selection effects, meaning it's really hard to distinguish between who gets to see a targeted ad. Well, someone who probably already expressed an intention to buy that product. How do you distinguish between the effect of the ad or the fact that this person already had expressed a lot of interest in buying the product? Would they have bought it anyway? These are what are called selection effects. The ads are selected to people who are more willing to buy the product. So it's hard to figure that out. We saw that there is increased revenue to content providers from targeting, but it tends to be larger than the correctly measured lift to advertisers. Again, it goes to maybe this difficulty in measuring lift. We also heard some interesting work from Catherine Tucker that suggested despite the idea that AI and big data algorithms know everything about us and are able to predict with just scary accuracy, that in fact she unpacked some of these algorithms and found that they weren't even, they were worse than chance at predicting gender, for instance, that there are a lot of that maybe the targeting and maybe the fears of AI, the privacy fears aren't that much, and also the flip side of that is the extent to which opt-in versus opt-out is going to have a big impact on revenue. Maybe we need to investigate that more carefully. So finally, well, the other thing, I didn't want to miss that last bullet point there. We heard some evidence from Lead Wagman on how opt-in at the same time reduces the quality of matching and data collection. This is in loan data using experiments from the San Francisco area where locality used opt-in versus GLB opt-out, and found that the quality of data when you can't sell it downstream turns out to be lower, and it was associated with larger foreclosures. Finally, again more evidence from Lead Wagman as well as Ginger Den, former director of the Bureau of Economics, saw that looking at the impact of GDPR on VC investments, some interesting, at least this is early phase research and looking at the short run, is that there was a negative impact somewhere between 27 and 56% in value for European startups versus their counterparts in the U.S. using good treatment and control methods. We also heard about work from Catherine Tucker and Amalia Miller about the negative impact HIT investments and on health outcomes. Finally, we heard a lot of theoretical papers that suggest that privacy regulation can have a negative impact on competition, primarily by softening competition to the extent that firms are able to gather data to more precisely target consumers. They can become more effective competitors. If you prevent that from happening or make that more difficult, you may have less intense competition. There's also the notion that bigger firms are more able to deal with regulation than smaller firms. However, these results are sensitive both to consumer preferences for privacy and on market structure, elasticity of demand parameters in the model. And again, it's theoretical work. We didn't really have any empirical work on that. So with bringing us up to date in setting the stage, I'm going to sit down here and begin a discussion with our esteemed panel to drill down on some of these issues as we think about the path forward in protecting our goals in protecting privacy protection. All right. So.
Thanks, James.
Oh, you're welcome. Thank you. So at least one person enjoyed my talk. Thank you. And so you'll get the first question because of that, Neil. The first. So when we think about the first part of the question, going back to what are the problems we're trying to solve. What you've thought a lot about this. What do you think of is what's the harm that any privacy policy should be directed at? What should we be? What do consumers want, and what problems are we trying to solve?
Well, I think the first step to answering that question, I'm going to take it back a little bit further, and I think the first step is to define what we mean by privacy, and it's a very complex word. There's a lot of values that people put into the word privacy. I've been on panels where the discussion has ranged from identity fraud, concerns about identity fraud, all the way to misinformation and election manipulation. Those are radically different problems. So what do we mean when we say privacy? And I've tried to think about a very generic version, like the most abstract version I could think of what privacy means. And I think this captures many of the definitions of privacy, but I'm sure Alistair and Paul and James will correct me if I've missed one. And that's that privacy is a constraint on somebody else's use of information about you. That constraint can be a physical constraint. Privacy is the effect of that constraint, right? And so that constraint can be a physical constraint, or it can be a legal constraint, or it can be a social constraint, or it could be a contractual constraint. So there's lots of different types of constraint. But when I say information, that's a pretty vague term as well. And so there is a scientific definition for information, and I'll rely on that a little bit. And so information is the content of a signal that's going from one party to another. So for example, the sounds that are coming out of my mouth contain information. They carry information. The light that's reflecting off my body contains information. And there are because we exist in the physical world and we interact with the physical world, we're constantly generating information. And we can't control all of it. We can try to control certain things. And in the physical world, we understand what the limits of that control are. So I can control the light that's bouncing off my body, or I can attempt to by wearing clothes, a fact that I assume you all are grateful for. But even when I try to constrain information in that way, I am giving off some information about myself, even with that constraint. And so when we think about information that way, it has some implications for privacy. If my goal is to constrain information, it immediately demonstrates that there's two parties involved. There's me, and then the party who is presumably going to collect or use the information, probably many other parties as well, and that my privacy protections are in tension with that person's use of information about the world, and that we have to draw lines somehow about how we're going to divvy up someone else's ability to observe the world and use that information, sometimes to serve me, sometimes to serve their own purposes, it depends. And my right, my control, my physical ability, but then also my interest in controlling information. And so when we think about it that abstractly, I think it comes down to how do we draw those lines in society? And we tend to focus on harm. When we get government involved, we tend to want to say, we're going to draw those constraints around where one person is injured. And what does injury mean in this case? Now I'm back to your question. Finally, I know. Quite a diversion there. So I think I want to do this in sort of concentric circles, right? So there are certain harms I think everybody agrees are privacy harms. And those are uses of information that might result in physical injury, financial loss, or increased risks around those two things. I think that those areas, people generally agree that those are the types of things that we might need government intervention to solve. Now, if you get further out from that, there can be disagreements around what other types. And the chairman mentioned a bunch of different types of harms, and some work that Maureen Olhausen did in talking about informational injuries also talked about this. And the types of harms that the FTC has looked at are not just financial harms, are not just these safety risks or safety injuries, but there's some other harms that are often mentioned in FTC cases. We do have reputational harm. We do have invasion of the home. Now, reputational harm in FTC cases has never been a sole vector for a case, but it is one thing that the FTC has recognized as a potential injury. So basically, because of that concentric circle approach, what I want to argue is that we are on the strongest empirical ground of government invention when we are closer to that core, and it gets less clear that we're doing good for consumers the further we get from that core. And in fact, there's some potential that we're actively causing harm, that we're drawing that line between the party who the information is about and the party who is using the information in the wrong place the further we get out. And the reason I think that government intervention is best justified the closer you get to that core is because government's resources are limited. And so if we are focusing on less tangible and more less objective injuries, and to the cost of focusing on objective, concrete injuries to consumers, we're probably on balance leaving consumers worse off. So if we're ignoring some actual harms that we know about, some ones that everybody agrees on, and we're doing other things, we might be making consumers worse off. Second, tangible objective injuries are easier to redress. It can be very difficult to revive somebody's reputation. And the question is, how can government do that? This gets to the point that James was making. Sometimes there are things that we should do but we can't do, right? That we want to do but we can't. And that's just a fact of life, and I think that we do ourselves a disservice if we pretend like government can do certain things that it cannot achieve. Tangible, objective injuries are easier to redress. When we're talking about financial harm, and we can put dollar amounts and compensation around physical injury, you can't make somebody perfectly whole, but we have models in the past through tort law that show how we might approach those problems. Other types of injury, it might be harder for government to work on. And finally, markets are better to solve this. Markets can be better at solving concerns where there's a multiplicity of perspectives on whether or not there's an injury. And this happens a lot in the privacy space, where what is one person's harm is another person's benefit. And in those cases, a government intervention that tries to draw the line between those two and says, well, I'm going to determine that this is a harm and this is a benefit, at that point, you're making one group worse off for the benefit of another group. And so we need to be very careful on that. And that happens less and less the closer you get to that core of physical or financial injury. That's not to say that there aren't other issues that government should play a role in, and it can play a lot of different roles. But we have other tools other than government intervention. And I think a lot of the other panels will talk about that. But that's sort of how I think about harm as the core harms and then a sort of concentric circles that build out from those. And we're safest with government intervention in the center. And we're taking more chances that we're drawing the lines wrong and potentially making consumers worse off the further out we get from that center.
Okay, thanks. Let me let Alistair and Paul kind of jump in. And we heard Neil say that he's thinking about our threshold question as far as what do consumers want, and Neil would focus this on addressing certain informational harms, maybe a core. What do you all see? And maybe Paul, I'll throw it to you. I mean, what do you make of? What do you think consumers want? And how do you? I know you've thought about the privacy paradox. How do we square that? Or do you have a way? Can you solve the privacy paradox for us right now?
Yeah, that's sure. Let me get to that in a few minutes. There's so much I want to say. Thank you to the FTC for having me here. Neil started by saying that he's been thinking about this for a long time. I think he means 120 years, because the presentation that he made, I think, reflects a kind of antiquated crab notion of both privacy and harm. And I think if our role as the first panel is to exhort the FTC, which has been a phenomenal leader in this space, but is at a crossroads where increasingly politicians, people of power, and average citizens seem like everything is going to hell in a handbasket, to use a technical phrase online. I think it's really incumbent on the FTC to think hard, and I'm glad to see so many of my former colleagues on the staff about what that means for this agency. And so I think that defining privacy is essentially about control of information, which is essentially what Neil did, again, harkens back to a 100-year-old definition of privacy and doesn't really fully account for a lot of writing and thinking that has happened about privacy and context and societal values of privacy. But I think our goal as a panel is not to wax philosophical about privacy generally, but let's talk about actionable harm. One of the best kind of written documents about privacy harm was the 2012 report and the 2010 staff report of the FTC. And there this agency talked about, and I didn't work on those wonderful reports, talked about fear and anxiety, and they indeed did talk about harm to reputation, chilling effects. And again, in a 2012 context, that's an important list, and it's a list that the FTC still has to put at the center of its work. They talked even about harms to intimacy and dignity, and the FTC has brought cases around that. But I think to talk about this in a 2019 frame, you really, really do have to update the kind of harms that not only the world seems worried about, but this agency seems well positioned to address. Manipulation is something we weren't thinking about much in the 2012 context, but definitely should gather new light. For subjects of behavioral testing and A/B testing generally, we didn't think a lot about us being unwitting subjects in psychological testing by giant corporations. And then, of course, as Neil said, privacy conversations today get to fake news and get to disinformation. And I don't think that's kind of a perversion of what we mean by the word privacy. I think there's a reason that there's a felt need to think about information flows and how they feed things like fake news. I'll pile like 3 more little things on the pile, but refer you to other people who have said much more about it than me: addictive technology, surveillance capitalism, broader questions about the Internet of Things. Okay, so I will take 2 minutes to talk about the privacy paradox, although I have about 14 minutes worth of things to say about it, and then I'll invite you to ask me another question, and I'll continue my answer. Let me give you the punchline, because I think that will make you want to hear the full speech. I think there's a privacy paradox, which is why economists think the privacy paradox is an interesting question, right? So there's a lot of, and let me just do this internally, like I'll use
I had an over-under on how long it would take you to insult economists. So.
Yeah, no, that's right. And I warned you in email that that's my shtick.
He was pretty patient.
I was pretty transparent that that's what I do. And I'll do this within a privacy, an economist framework, right? In terms of kind of behavioral economics and in terms of the kind of cognitive manipulation that happens around choice and consent. It's crazy to think that any of the preferences that we're measuring in any of these quote-unquote objective studies are revealed. They're manipulated, they're bought, they're controlled. We're talking about companies that have made their great wealth by being the greatest purveyors of information that the globe has ever seen. And so the fact that they can trick people to act against their preferences is not surprising, I think, especially to people who think outside the economic framework. We can continue to dive deep into why economists think that's an interesting question, but I hope we don't spend too much time in this workshop worrying about the privacy paradox, because there's all sorts of other indicators that this isn't really meaningful notice and choice that's happening online, and because the FTC has pegged privacy and privacy protection to notice and choice, we should really respond to that. Okay, I've taken too much time. Thank you.
All right. Alistair, do you want to jump in?
Sure, I would. I think one of the problems that, the way I see it, is that we're trying to address the situation where just by living in the world, your entire life is being tracked and manipulated. And I think, so when I think about privacy, I think about different stories. So in 2017, the Massachusetts AG settled with Copley Advertising. They were waiting till women were inside reproductive health centers and then sending them right to life chats saying it's a child, not a choice right now, don't do it. This feels very invasive to people, and you're trying to live your life. You wear a Fitbit, it knows everything about you, including the state, when you think about it, of your relationship with your partner. In-home device knows everything about what's happening in your home, so it knows where your phone normally sleeps and where your partner's phone normally sleeps. And if suddenly the phones are sleeping in different parts of the house, the algorithm knows before anybody else in your life that your relationship's in trouble. cars are essentially data gathering, machines on wheels. And they know how often you eat at a fast food restaurant, how often you go to the gym, and how long you stay there, and what time you get to work, and when you leave, and whether you've been fired before anybody else knows whether you've been fired. So we have to live our lives. The technology is interwoven into our lives, and we really don't have any choice. And I think the harm we're trying to address is, how do we start to get some kind of balance back just by living our lives? And yes, at some level you could say, well, this is all voluntary. You get to use this technology. You choose to use it. But your choice that you're left with is to go kind of live in the Stone Ages and not really be part of the modern world. So I don't think that, for me, harm is not just physical injury or financial loss, though I think those are important ones. But I think it's important to kind of step beyond that. And so our framework, in terms of this notion that government can only do so much, well, but if you give consumers an easy choice, an easy way to do that, I think you'll find that consumers will flock to it. One of the problems is that it's super complicated to take advantage of your own privacy. I'll give you a little story. I installed Google Photos on my phone to upload photos, and then I thought, I'm going to just log out, and just when I have a good connection, I'll log in and I'll upload. I don't want them tracking me all the time. Well, it turns out you can't. And then you Google it online, and you actually have to you have to delete the app from your phone. You can't just have it on your phone and log out and then log back in. You don't get that option. And these companies make it very difficult for you to take control of your privacy. And so what we think is giving consumers choice that is effective is the way that you're really going to make a change here. And that's why Ccpa, the law, not only says make it easy, so you have a button on any website that collects your information saying don't sell my information, but it allows for the third-party opt-out. And what that, I think, is going to create is a world where your browser will easily be able to indicate your opt-out choice. And your device, your phone or your computer computer for your browser, but your phone will also be able to do it. So you won't have to go through the torture of trying to figure out on every website how to take control of your information. And I think that's where, for us, where we're headed, and that's why we went that approach.
Neil, I know that Paul
Sure.
took on a few things you said, so I want to give you a chance to respond.
Sure. So, I think all of these are old ideas, Paul, to be fair. And in fact, the idea that our technology is manipulating us is as old as technology is. And this, you can follow Pessimist Archives on Twitter, and you'll see just tons of stories, or listen to their podcasts about how TV, advertising, novels, comic books, speech, writing was a technology that was ruining society by manipulating people in ways that they could not control. And what we've learned over time is that it takes some time to adjust to these things. Law is part of that adjustment. It's not the only adjustment. And in fact, if it's not done well, it actually retards the progress that can be very valuable. And so, Alistair, I think you made a great point that we live in this amazing technological environment where a lot of the problems that we've been trying to solve in our lives are now adaptable to being solved through software. And the key to that is information. And in order to get those benefits, we need to maximize the ways that we can share that information. And we also need to respect that information that involves us is not purely about us. And so my interactions with somebody's computer out there on the internet, I think sometimes we have this perception that I'm sitting in my living room, I'm browsing the internet, and so the internet's like on my computer. That perception is not any more correct than if I wandered out into the streets naked and then said, nobody is allowed to look at me. We don't have rules that say that. We have developed other protections, and we've helped educate ourselves on how information works and what we can do. And some of that means acknowledging that our uses and our interactions with other people, that we need to have a conversation with those people as well, and that those choices can be they can be to choose to not use the service. They can be to choose to do other things. They're not a one-way conversation where if I don't like how the deal is going, I am going to run to somebody else to make that person do things the way I want them to. That's, sometimes that can make sense when there are certain types of harms, but again, that's at the core set of harms, not the, and I don't think we need to perpetuate the idea that we have somehow more control than actually is feasible or possible to achieve while gaining the benefits of that technology at the same time.
Thanks, Neil. Paul, I want to go back to you, and it was something that Neil said, and I think this is maybe goes to maybe not the core, but this notion of property rights over the data or over the information. Do you look at approaches like the Gdpr and the Ccpa, and there seems to be at least an implicit entitlement to consumers to have some control over the information that online services collect about them. That's kind of the part of the core. But as Neil posits this that. Well, do we necessarily have a right to that information? Is it jointly produced? Is it jointly owned? I mean, and I guess I would ask more bluntly, are property rights even the right way to think about this?
So property rights are not the right way to think about it. So this isn't about, can we convince people to take $1.25 and then we can market any way they want. Implicit in the question, and I think implicit in the kind of core foundational argument, and explicit, it was in one of your slides, is that when we have something like meaningful and restrained privacy law, we're going to kill the internet as we know it. So let me just riff on that for a second. So I think both the empirical evidence that you had on your slide, but I think more broadly speaking, is not nearly as strong as is represented. And in fact, it's always curious to me that the demands for rigor only flow in one direction in this debate, which is we need, more proof that these harms are real harms. They don't feel like real harms, and yet we don't cast the same skeptical eye on claims that if we, have Ccpa or if we have Gdpr, this is the end of society as we know it. When I was at the Federal Trade Commission, I think I'm allowed to talk about what I said to people because it's what I said to people. I asked every economist I talked to, usually only would talk to them once and then they would never come visit me again. I would say, what is the empirical proof that behavioral advertising specifically has had a meaningful, appreciable impact on innovation over not having to pay for services, which is usually what people will argue, but over contextual advertising. And I think one of your slides said, well, now we know it's been proven. It has not been proven. There's a thin reed of evidence. It's a little thicker than it was back when I was at the FTC. The only people who can do these studies are the people who can get the data from the ad companies. One of the kind of noteworthy studies in 2013 was by a Harvard Business School professor who refused to put it in his scholarship part of his CV. He put it in his paid research part of his CV. And remember, we're talking about contextual advertising, which fueled the massive growth of the internet up till about 2007. Sure, there was some behavioral at the time, but companies like Google hadn't yet flipped that particular switch. And so there's a compared to what problem whenever we make claims about we're going to kill the internet, because it doesn't mean compared to a world with no advertising, it means compared to a world without kind of massive dossiers built about every individual on earth by small companies that have only existed for a year. And so the question is, what if we could wave a wand and we could say no more kind of third-party tracking just for behavioral advertising purposes? You know what my guess is? We'd have tons of innovation and tons of money. And what's really exciting is the innovators would not be focusing on, to quote the famous Facebook engineer's quote, the best minds of my generation are trying to get people to click on ads. They'd be focusing on meaningful content and making a connection with their users and building community and improving society. And I know that's not the kind of innovation that might excite some people at the end of the day, but it really does excite me. And so we have to be really, I think, skeptical of claims and not take it as a given that privacy law kills innovation. I think quite to the contrary, it can serve innovation.
Go ahead. I did want to maybe correct the record a little bit. I mean, in fact, I think the research that was shown that I discussed was not that kind of the opposite, that actually that, whether it's Florian Zettelmeyer or Catherine Tucker, Abby Goldfarb, that yes, that behavioral advertising tends, an ad with a cookie sells for more in an auction market, generates more revenue, but the lift may not be as large. So the empirical evidence, and certainly there was nothing that I think I said or that was presented at the other workshop that suggested that the internet would die if we didn't have behavioral targeting. So I just want to correct the record as well. Though I mean the only evidence that went maybe directly to that was the VC funding study with Liad and with Liad Wagman and Ginger Jin. But anyway, with that, I know Alistair, you wanted to jump in.
Yeah, I just wanted to maybe correct one thing that Neil said. I don't actually think you have any effective choice. You have to use the technology. So this notion that you have some choice about whether to use it or not is just not. It's just, I think it's misleading at best. I think that. And going back to the contextual versus behavioral, so if you look up Digiday, did an article on New York Times. New York Times ended the behavioral advertising in Europe post-GDPR and showed that its advertising revenue went up in this article, and it came out a couple months ago. As Paul said, the technology that fueled the creation of Facebook and Google, the contextual advertising, no one really finds that very offensive. It's this sense of being tracked and who you are being anticipated before you even know it. That's this kind of weird technology that I think people really are objecting to. And in terms of harms, I couldn't agree with Paul more. Everybody always talks about the harms. My question is harms to who? It's not harms to the consumer. It's harms to the market cap of Facebook and some of these other firms. And I think that the last time you ever heard, a consumer saying, my problem with that site is I just don't get enough behavioral targeted ads. I mean, who's ever said that? And so some people will really say, I never want to see another ad for, the wrong gender product. Does anybody really care? I just don't find that is a harm that we should be spending any time focusing on. What we should be spending time, and the reason, again, everybody's talking about intervention. Remember, Ccpa just gives you choice. If you don't want to do anything, if you love it the way it is, don't do anything. But the reason that all these people, all the companies are waving their hands, panicked about choice, is they know that if consumers have effective choice that's easy to implement, they will take it. And that's why everybody's fighting to try to stop that from happening, because they're making so much money from selling your information. And people are tired of their information that they're generating just by living their lives, being sold, and themselves being the market and being the product. And so that's why I think there's so much Sturm und Drang about, what will happen if consumers don't give them the choice. Well, I believe in consumers, and I believe that they will make the right choice.
Neil, did you want to react to any?
Yeah, I believe in consumers too, and I believe they are making choices in the marketplace every day right now. But what we do know absolutely from behavioral economists is that choice frameworks matter a lot. And you know this because you made some choices about how you offered choice. And in doing CCPA. And so when you say that it's just about choice, it's not just about choice. It's about the frameworks in which consumers make choices. And when those choices are one size for all the certain problems, and when consumers have widely ranging privacy preferences, different choice frameworks are better for certain consumers than others. And so if we're going to just say, here's the one single choice framework that everybody has to do, we're going to be benefiting some consumers, absolutely, without a doubt, and we're going to be harming others. And I just think it's really important to keep that latter group in mind. There are people who don't want to be bothered by certain things, and they want to use these technologies, and they like the ad-driven ecosystem. And like me, I've often actually said, I wish my Instagram feed had a filter where I could just see the ads because I saw this thing I really wanted and now I can't find it. And that is a targeted ad, and I'm a fan. I actually have purchased many things from Instagram ads. So I do think that there are people out there, and I just to get back to the privacy paradox for a second, I agree with Paul. I don't think it is a paradox. I think that the privacy paradox is less about a sort of failure of a consumer to make the proper judgment when they're in real life. And I think it's more of a failure of the researcher to be empathic to people who might make different choices than them in the real life. And so to me, the people who call it a privacy paradox tend to be people who are puzzled by the fact that consumers would say, I like X, and then when they're faced with choices where they have to make trade-offs, they make a different decision. To me, that's not puzzling. That's how consumers are all the time. It's not a paradox. It's only a paradox if you don't understand why somebody would do that, and that's a failure of the researcher's empathy, not of the consumer.
So because choice is kind of the topic on the table, I mean, my prediction for 2019, let's do this like a bad TV show, is this is the year where dark patterns really becomes the kind of thing that we're really talking a lot about. And we'll see, I happen to know 4 or 5 different teams of researchers who are trying to kind of give a lot of heft and meaning and rigor to what we mean by that. And it really fits within the kind of economist framework. So for those who haven't encountered it as much, right, this is the notion that our choice architectures, our choice opportunities are just completely muddled and clouded by the little tricks that companies play to get you to consent even though you may not want to. And so this is as simple as putting the yes button in a really prominent dark font and the no button in a grayed out font, which is harder to perceive. There are kind of more dramatic examples that Woody Hartzog talks about in his book. Yes, I would like your health service. No, I just want to bleed to death. And so there's all sorts of kind of behavioral cognitive tests. And the most pernicious part of it is how they're completely engineered through A/B testing to be far more insidious than any like crazy innovator could come up with on their own. And so they're meant to really, really just find you at the most vulnerable moment and get you to click yes because you just want to get to that Instagram ad. And so I've been thinking for my part, so I've got a little paper coming out with Kathy Strandberg and some of her fellows at the Stigler Center, which is like this law and economics powerhouse. I'm not sure why I was invited to take part, about how we might make dark patterns an actionable thing, both through new legislation, but even through the work of the FTC, right? So that if our entire edifice is built on this notion that there's free consent and choice, well, let's take really seriously what happens at the moment when the user consents. And I think what we will lead to, and I think it'll be in a way that even the economists will kind of have to agree with, that there are some devious tricks that are played at that moment that really do undermine the fundamental notion that this is a contract, this is something meaningful, and this is something that we should premise, for example, FTC lack of enforcement on. And so I think mine will only be one of like 4 or 5 studies, including some empirical work on this, and I think people on the Hill are probably likely to pay attention as well.
Well, now that we've solved all of what consumers want and how we should go about it, now I actually do want to turn to how we should go about it, kind of switch gears and think about the shape or the form of government intervention. And Paul, while I have you, you know, there's kind of broadly there are 2 ways you can regulate ex post enforcement, which in large part is what the FTC does, that we use unfairness and deception to go after practices that are harmful. We use Section 5, but more recently you have the GDPR, you have the FCC repealed privacy law, the Ccpa to perhaps a lesser extent, but a little more on the ex-ante regulatory side, where they tell firms or marketplace participants, these are things you must do. These are things you have to do. So when we think about either an ex post, maybe harms-based approach, or an ex ante regulatory approach, what do you think is the right way to go, or a hybrid of both, or you don't have an opinion?
No, I always have an opinion. Yeah.
Okay, I should not have said that. I forgot who I was talking to.
No, I think but it's probably an obvious opinion, which is yes and more of both.
Okay.
But I will give probably the only opportunity for me and Alistair to have a little space between us. I'm not as intent on kind of big wholesale FIPS-based kind of approaches that sweep all companies in. I think they're actually important if they can be achieved, but I think they're neither necessary nor frankly sufficient for the kind of privacy that I have in mind. And so I wouldn't personally pour a ton of energy into a nationalized CCPA, partly just because I think the dark patterns problem is going to persist. So something based on notice and consent and choice isn't likely to be meaningful enough, partly because I think the political process will water down anything like that so much. I'm happy with California, and I would like to see it continue to be the law of at least that land. And so let me just say one thing about ex post and ex ante. For ex post, yes, we should continue to be aggressive in our enforcements. We should kind of do more with the dark patterns that I was just talking about. But ex ante, I actually have always said, and I think I depart with a lot of privacy advocates on this, that there should be more laws tailored to sensitive information. So we should have new laws that kind of find the little gaps in types of information that are so deeply sensitive, so connected to provable harm, and yet for some odd reason we don't protect in this country. And so the most obvious one is location information. I mean, there ought to be, and I don't care which one, past any of the right to location privacy acts that have been proposed over the last few Congresses, but there should be a kind of fundamental ex ante restriction on what we can do with the specific accurate location information of people. Doesn't mean we would like drive out of business any company premised on location information, but it means we would really ramp up both the notice and choice that's required, but more importantly, the kind of substantive obligations about what to do with location information. It should be like Hipaa, it should be like FERPA, and it's kind of crazy to me that it's not.
Well, thanks, Paul. Neil, I mean, obviously you began your talk talking about specific consumer harms, and that's what intervention should be addressed. So do you have a view on ex post enforcement directed at harms? Should there be, as Paul suggested, and maybe in some ways what the risk-based regime that the U.S. has in some ways? I mean, you're right, we don't have location, but we have Ccpa, which has specific requirements for kids. We have Hipaa, specific requirements for health information. What are your thoughts on harms-based ex ante versus harms-based ex post versus ex ante regulatory approach?
Sure. So, well, I'll take the opportunity to be in slight agreement with Paul. So that's always nice. I do think that ex post has a lot of virtues in the ability to focus on to address the challenge of not being able to predict the future and setting big abstract frameworks into place based on how the technological world works right now is very, very, very difficult. And in 10 years, I think a lot of those frameworks will look out of date at best. And so ex post approaches that focus on what is a particular type of harm that we're worried about, or what is a particular type of use that we're worried about, and we're gonna watch and see how companies behave, and then if there's injury to consumers, we bring actions. I think that approach has that virtue of not having to predict the future as much. It also has the virtue of not having to be as abstract. So we can look at a specific case, get information about that. We don't have to have these big picture arguments about what, in the abstract, what is a privacy harm. We can look at the specific case and say, was a consumer harmed in this case? And there we have more evidence to work with, and it's easier to make a judgment that is just to all parties involved. And so I do think it has a lot to be said for it. And on the dark patterns point, if I could just jump to that, I mean, this is not new to the FTC. The FTC in ad practices does this all the time, right? There are all sorts of dark patterns in DMP, where dark patterns where people get involved in loans or they get involved in advertisements for supplements, where there's all these patterns around them. And so I think that's great work. I think there's a lot of evidence that the FTC can draw on around that issue. I think that those parts of the FTC's work have shown that economists bring a lot to the table there, and that when you're focusing on economists bring a lot to the table there, and that you can look and see how to attack certain specific bad practices and bad actors without condemning advertising as a whole or any specific type of advertising. And I will say, to Alistair's point really quick while we're on that, people did find contextual advertising frightening and weird. They did for a long time, and then they didn't. And now in contrast, it's the thing that used to be scary, and now we're scared about something else. And so I think that is the trend in privacy and in technology generally, and I expect it will continue regardless of what what laws are in place.
Thanks. So, Alistair, I wanted to move to let you react and also just maybe talk specifically about the CCPA. Obviously, that ended up as an opt-out regime, and I'm curious of what sort of considerations went into. I mean, it's opt-in for 13 to 16, and then parental opt-in for under 13, consistent with Ccpa. But for anyone over 16, we've got an opt-out regime in the CCPA. So I'm just let you react to whatever you've heard, but also discuss what went into thinking about opt-in versus opt-out in the CCPA, and how you all ended up there.
Yeah, well, I think what we wanted to do, to the point of, you don't want to create a law that's stuck in time. So one way to think of CCPA is it really is just a framework that grants the AG in California rulemaking authority to move with the times. And so what are the basic rights are? You get the access right, but you really, the one right around, I think the most important one is the opting out of the sale of your information. And so we were and are pretty agnostic about, we believe in the consumer, and we believe the consumer can make that relationship with the first party. And so we don't put restrictions on the collection of information by that first party. It's just that it's the, promulgation of that information all the way out into the system where people don't have any control of it, and they don't understand or have any control over what's going to happen to that information. And that's where we drew the line. We said we should give people the right to stop the sale of their information. And again, going back to the choice, if you like it in the ads, there's nothing you have to do. And so there's no intervention, and I think it's a very sort of light regulatory touch in that sense. And again, we don't stop that first party from collecting the data. And in terms of enforcement, I think if you look at the sort of ex post enforcement, my point would be just take data breach. It hasn't worked, right? Because you see the security, the data breaches again and again and again, and so what we are suggesting is, look, put a line, have a reasonable security framework, and ours says if you encrypt the data, or if you redact the names out of the data, or if you have reasonable practices and procedures in place, then there's no private right of action. We do have a limited private right of action around what I'm calling negligent data breaches, which is just like the cop when he stops you speeding. He doesn't ask you why you're speeding; he just gives you a ticket, or she just gives you a ticket. And that's kind of where we are with the data breach. I do think the whole problem with how are you harmed to Equifax? You have this data breach. Try proving to Equifax that your identity was stolen 6 months later because of that data breach. So I think we chose opt-in because opt-out because we think it's going to be effective. And I was really focused on how do you get something effective. And because we allow for that third party opt-out, I think consumers are going to be able to do something simple. And that's really important because no one has the time to read privacy policies. No one has the time to go through and find out where to get the settings in this particular app. But if you could set it once in your browser and forget it, or once on your phone and forget it, I'm convinced that tons of consumers will do that. And that's also why I'm convinced this has suddenly gotten so much attention, because companies realize that, wow, this is going to be, we're profiting immensely from selling everybody's data, and we can't let them have this power to opt out of the sale of that data. And I'm convinced also that these companies are going to do just fine, because again, we don't stop the company from collecting or using the data on their own. So if they can make an argument to you that they need to have your data, Uber does need to know where I am, Uber does need to track me, Uber does need to have my credit card information, great, that's fine. But do they need to sell it? That's the second question.
Can I say one more thing about ex post? Because I think it's become fashionable to bash the FTC as ineffective, and call me a hopeless homer because I worked here. I think the FTC is really, really effective and smart about the way it uses meager resources. So obviously, if anyone in Congress is listening, give them a lot more money so they can really carry out their enforcement mission. I'll also say that I think, and I'm saying this in a very pointed way, I think a lot of the community is looking at what happens in the next whenever about Facebook and Cambridge Analytica. I think a lot of minds will be made up about whether, and probably shouldn't all turn on that one case, on whether the enforcement mechanism still has life. And then my exhortation to kind of my co-panelists is stop challenging and funding challenges to actions like in the security space. I know this is the privacy conference, not security, but if we want an ex post regime that works, we can't have kind of these pointless, endless litigation about whether or not Section 5 even applies to security. And so that ties the hands of a lot of the enforcers. Ex post can be a lot more than it has been were it not for challenges like that. So.
Well, I think there are certainly areas in which FTC authority to bring ex post enforcement needs to be shored up given some recent cases. And so I think I agree with you on that. I think I would agree with you on more resources. And I do tend to think that ex post is a better approach. And if we can strengthen that, it solves a lot of the problems better than ex ante big picture regulation. And I somewhat disagree with Alistair. I don't think that all of the companies that are worried about the CCPA or the advocates who are worried about it because they sell consumers' data and they think they're going to lose money. I think there are lots of reasons to be worried about the implementation costs of CCPA. And I'm not a CCPA expert, and you certainly are. But I've heard many more concerns from many people who don't have a stake in selling consumers' data about the compliance costs that will come about from having to undertake the efforts that CCPA requires.
Let me, I'm sorry, and I'm going to let you respond, Alistair, but we're running short on time, and I've gotten some really good questions from the audience, and I apologize ahead of time. I probably will not be able to get to all of them. But one was directed at you, Alistair, and I think it fits into the discussion we're having, if we end up having a lot of opt-out, is that going to lead to a lot of things going behind a paywall, or in the sense that, or there'll be free riding in the sense that the people who don't opt out foot the bill for everyone else, and then maybe eventually content will end up behind a paywall. Do you have any thoughts on that?
I think it just depends on your business model. If your business model is being transparent with consumers and transparent with what's happening to their data, so consumers don't mind what's happened to their data, I don't think much is going to change. If your business model is based on making a lot of money from selling your consumers' data while they don't think that their data is being sold, I think that's going to be, you're going to have a problem. I mean, I think that, to go back to this idea of regulation, the cost of regulation, I think what happens is technology always outpaces society's ability to understand it. And then eventually society sort of wakes up and says in the 50s, wow, a lot of people are dying in car crashes, maybe we should have some auto safety. Or in the 70s, they sort of say, gosh, I can't see across LA. Maybe we need to have some regulation around, clean air. I think at the time, industry always, and I'm a business person. I mean, I went to business school. I've been a business person for 25 years. I think business just tends to react by saying, oh, regulation is going to be super expensive. Everybody's going to lose their jobs. This is going to be a disaster. And then you know what? Now you can see across LA, and car makers still make money, and the world has not, ended because we have cleaner air. I think this is sort of a similar scenario where right now there has been no regulation, no really effective regulation around this space and privacy, and I think California is showing up with some effective regulation. And I think companies are doing what companies always do when there's regulation on the horizon. They say, "Oh, look at the cost. This is going to be a disaster. People are going to lose their jobs." And the reality is, these companies are going to do just fine. They're going to make money. And I think that this is just society waking up and saying, wait, this has gone a little too far. We want to maybe start taking some control back. And that's why we had 630,000 people sign our petition. It's more people than live in Wyoming or Vermont. That's why, it never polled below 80%. And that's why both houses of the California legislature acted unanimously, both times, not a single vote against this. Because people understand this is an issue whose time has come. And I think California is just the vanguard, as it has been in so many other areas. And I just happen to capitalize on this sense that people have that this is just out of control.
So another audience question, and this kind of goes back to something Paul had talked about earlier, and it's really more pointed and specific. Do you think that the dark patterns, the FTC, has sufficient authority under Section 5? I know you and Neil had a little back and forth about that. Do you think that there needs to be something additional, or would it fit under current unfair, deceptive acts and practices?
Yeah, so I think that dark patterns, if extreme enough, well, obviously sometimes they're just deceptive. And I take your point, Neil. I did not I should have highlighted ad practices, marketing practices, having, they are kind of the experts in DC to think about dark patterns. So first of all, they might be deceptive. If they're really, harmful, they might be unfair. But even if they don't quite rise to that level independently, I think the broader point I was making for the FTC is that they undermine the kind of notion of free choice. And so they might factor, for example, into the cost-benefits balancing that we're forced to do under Section 5N, right? And so they might be, well, you opted into this and look at all the benefits you got, but you really didn't opt into it because the dark pattern interfered with your ability to make a real choice at that point, right? I mean, so it's a little round trip through FTC doctrine to make it relevant. But again, it's couched in the language of economics, so I think has a better chance of kind of having some sort of change within the commission itself, right?
Well, in our remaining time, we don't have much left. I did want to turn to Neil, and again, we talk about intervention and the potential costs and benefits of intervention. One of the things that comes up, that came up a lot in our hearing in the fall, and that you read about both in academic literature and is in the popular press, is the potential impact on competition of privacy regulation, whether it's, again, we saw some theoretical models that discuss how it could potentially soften competition with if entrants have less access to data, less ability to target and poach from incumbents, and then in general, you have the notion that large incumbents may be better able to deal with opt-in, strict privacy regulations than, say, new entrants. So what sort of, how should we think about that? Is that an important consideration as we go forward and grapple with some of these ideas?
Yeah, absolutely. I mean, I think the effect of regulation on competition isn't just about changing people's business models. Often, it is a way that companies use to cement a business model in place when they are afraid of competition. And so I think Alistair is 100% right that the big companies will continue to make money here. I think they will then use that money to use a regulatory framework in the way that they are free and open to do through lobbying to protect their interests. And I think opt-in and opt-out are compliance regimes in which big companies with good brands, that consumers are familiar with, they can get over that threshold. But new companies that don't have an established brand, or less well-known companies, or companies who work in a different space but want to move into a new space, they have a much harder time getting into the consumers, getting consumers to say yes, even if they have a more privacy protective product, because consumers still use the brand signal a lot as a way that they make choices. And so I do think that there's that challenge, that regulation can often cement business models into place, that the market pressures, which I think we're seeing there are pressures in this space for companies to act in different ways, that market pressures would push towards naturally, and companies can use regulation to hold back that change. And I'd just add one more thing around CCPA in particular, that many of these rights, one of the challenging things about them is that companies who were collecting some subset of data, in order to avail consumers of the legal requirements that are in the law, may now have to collect more data. And so there is a tension there on how you are improving consumers' privacy by forcing a sort of centralization of information in companies in order for them to be able to validate that it's so-and-so that requested the information about them. And so I think there are some challenges there. I don't want to pick too much on CCPA. I think these are big challenges for any sort of overarching framework that tries to set a single solution for things that the market has and is continuing to find many different solutions for.
We are out of time, but I do want to let Alistair and Paul jump in if they want to have one last comment.
Two things on that. That, with all due respect, that last comment about having to collect additional information, there's multiple places in the Act that says that for a single one-time transaction where you're not collecting personal information. You don't have to collect additional information. This is the kind of thing that people throw up to say, this is going to be a disaster. But if you're collecting personal information, then you've got to be able to re-identify it. But if you're not collecting personal information for a one-time transaction, there's no requirement to keep it. What I'd also say is, hey, before the framework goes into place, 90% of new digital ad revenue is going to two companies. They have 79% of the market right now. So don't talk to me about competition. This law will do the most benefit to increasing competition by allowing some of these companies to start having a little more level playing field by stopping this data moat from just getting bigger and bigger and bigger around these giant companies. If Google and Facebook can't ubiquitously track you across every single thing you do on the web, that will have a tremendously pro-competition effect.
I mean, real quick, I think we actually can end with kind of a baseline agreement, although we see it in slightly different ways, which is I absolutely think that we ought to cast much more regulatory scrutiny on giants. And so I've written a piece called Regulating at Scale, which argues that we ought to have laws that do one thing when you have 100,000 users, something else when you have 1 million, and something entirely different when you have 100 million or 1 billion. It's crazy that we have companies with 1 billion customers, and so they must live up to the highest standards. They may suffer the biggest fines for penalties. They really must be kind of paragons of behavior, partly because of the damage that they can instill on like cities, populations of people, but partly because of competition, partly because they have a lot of power, and a lot of our law is kind of geared towards helping them protect that power. And so if the FTC can use its prosecutorial discretion, for example, to go more after giants and after tiny startups, I'm all for that. I think that's a great policy to enact at the commission. So.
Okay. All right. Well, join me in thanking our panelists for the time and great discussion this morning. And we will have a break until 10:45.
to do an introduction. Awesome. And then when you're finished, you'll just pass it to Aoife because she has a few slides. She does.
Okay.
Awesome. Right over here. Welcome back, and thank you for joining our discussion today of the data risk spectrum, from de-identified data to sensitive, individually identifiable data. My name is Elisa Gilson, and I'm an attorney in the Division of Privacy and Identity Protection. I will be co-moderating the panel with my colleague, Cora Hahn, who is also an attorney in the Privacy Division. We are very fortunate to have with us 5 distinguished panelists: Devin McGraw, General Counsel and Chief Regulatory Officer at Citizen; Jules Polonetsky, CEO at Future of Privacy Forum; Michelle Richardson, Director of the Privacy and Data Project at the Center for Democracy and Technology; Aoife Sexton, Chief Privacy Officer at Kurata; Shane Wiley, Chief Privacy Officer at Cubic. And before we begin the discussion portion of our panel, which will be most of our time together, Jules is going to start us off with a short presentation that covers some of the basics of de-identification, what it involves, what are some of the relevant standards, and what are some of the challenges to de-identifying data. So Jules, could you please start us off?
Thanks, and I'll jump right in, of course, with the slide that you expect. Here are all the small sampling of the prominent de-identification attacks that have led many to argue that de-identification is impossible in a world of big data. Paul Alm famously wrote about the databases of ruin that are being created by the failures of de-identification. Reality, of course, is that at some level, we are all probably confident that you can de-identify. There are 1 million people in the city. Well, that's a pretty big number. We don't think there's a risk. What people mean, we think, when they talk about we're skeptical that de-identification works, is they mean that data that actually has useful, valuable, sensitive, practical information in it, useful for research or products or services, that creates that risk that if not properly minimized, you can re-identify. So let's look a little bit at just a couple of these, and then we'll try to pull out some of the learnings from them that help us frame what is personal and what is de-identified. Let me start with one close to my heart because it led to me becoming the Chief Privacy Officer at AOL many years ago. The researcher who shared online for researchers, a PhD working at the company who shared for researchers, a data set where he had eliminated the screen name, the AOL screen name associated with months and months of search results. Probably not any data set that a credible de-identification expert would consider anonymous information, but a young, smart, noble, PhD said, well, there's probably no risk in putting this data out. And obviously, it was trivially easy for a reporter to go through this detailed data set. So I don't know we learn a lot from it other than if you've got a lot of data, a long amount of data, many, many search results. People search their own name, addresses, all sorts of information. Simply removing the most explicit name, the screen name, the personal name, isn't going to do much to identify. Okay, so maybe not a huge lesson other than dangerous to make public great detailed data sets. More sophisticated and perhaps more interesting for our analysis is LaTanya Sweeney's work, Arvind Narayanan and Vitaly Shmatatov's work, where they conducted what are known as linkage attacks. What is a linkage attack? Well, when you have a de-identified data set and it's joined with a publicly available data set that has information in it, using attributes that are common to both those data sets. So what was compelling about the Netflix attack, right? Netflix released for its prize, testing the ability of the public to come up with better algorithms, movie ratings and dates. Doesn't seem like a very high-risk set of information, and there wasn't even a lot of it, which was one of the critical sort of pieces. It was simply a number of ratings and dates. And of course, they should have, if they were doing effective de-identification analysis, said, is there another data set out there that might actually name some of these people and have more information about them that would enable additional learning that we have placed in this data set. And of course, the IMDb data set, which has rules against crawling the entire thing. So the researchers didn't crawl the entire thing and say, hey, look how much we've identified. They identified 2 people because they had a very small sampling. But what they proved was, look at that. These are easier to do than you might have thought. This can be done with a fairly small amount of data. And beware, there are all sorts of data sets out there that you may not be aware of that could contribute to a linkage attack like this. Similarly useful to helping illustrate the challenges of de-identification, at least when data sets are made public, was the work of Professor Sweeney, where, again, the linkage attack here relied on the fact that the data sets that were made available included procedures, date of birth, gender, other indirect identifiers that she could use when she went to a very important and essential data set that is publicly available, the voter registration databases, right? Although they don't have everybody in our population in there, there is, and we all have to take into account anytime we think about the identification, the fact that there is a data set that has things like gender, date of birth, and your precise address. So it's no surprise that almost every expert who works on de-identification is highly aware that including those sorts of indirect identifiers in a database are high risk because there's this lookup database that can put those sets together. Interesting to note that if one had followed the Hipaa standards, one would not have released a data set that would have included that level of precision. It would have had just perhaps birth year and the first 3 of zip, which might have made that attack much harder. Okay, so let's dig into the basics when somebody looks at assessing a data set and seeks to understand whether it's personal and whether they can de-identify. So of course, start first with, are there direct identifiers? If there's a direct identifier in the database, we understand by definition it's a personal database. So what is a direct identifier? Can I identify somebody in this data set without additional information, just it's their name? Yes, we might have a John Smith, which doesn't tell us a lot, but is there information that if I look at it without any further research, I can identify this user? Or can I cross-link this information in a trivial way to other information in the public domain? That's a definition from the one of the ISO standards. Experts might add, or widely available, right? So I may not have your name, but if anybody can go ahead and just look up that code online, or maybe by paying a small fee, perhaps it's widely available. Obviously, on its face, we've got a identifier that is personal. Indirect identifiers, for better or worse, are the source of all of these attacks that we've seen on these public data sets. They're also the kinds of data that make data sets precise, useful, valuable for research, for products, for all the various uses. Sex, date of birth, age. Again, if you're not living in the world of de-identification, why is my sex going to be something that is a high risk? Well, we've just divided the data set right in half, male, female. Maybe life's more complex nowadays, but obviously all of the indirect identifiers that start letting us slice the data set and enable us to reference external databases for linkage attacks. Professor Sweeney, in her work on K-anonymity, proposed that for every combination of quasi-identifiers, of indirect identifiers, that there be at least K records. And this is how we can assess how risky the database is, how many, if there are a huge number of people with that same set of quasi-identifiers, obviously there's some safety in that. I'm leaving aside for the moment now some of the de-identification risks, such as we saw recently with the census, where although the census was releasing statistical data, the fact that there were so many multiple data sets that could be overlapped enabled experts to narrow some of those cells enough to make smart judgments about individual users. So it's clear that perhaps much of the interesting debate here is less over what are direct identifiers and what happens when I make data sets public, where clearly every possible risk needs to be considered. But what happens, and this is a chart that we did a number of years ago, that tried to take a look at how does data actually exist at organizations. Sometimes it's explicitly personal, sometimes it's perhaps got some kind of masked code to it, sometimes it's got a code that can be looked up, sometimes an effort has been made to pseudonymize that data, meaning remove those direct identifiers, but leave those indirect identifiers. Sometimes that data is protected. Sometimes it's very well protected. That pseudonymous identifier could be a one-time ID. It could be something that's widely used that allows broader linkage. And then we can talk about data sets that go through more statistical protection. So on the next couple of slides, I simply want to show how some of the debate, which ends up being around that outer boundary, do we actually care about covering this data in law? Do we want to protect it at all? Ends up missing perhaps some of the more robust debate, which is, yes, we do want to capture it because it's probably not a data set that we're comfortable making public. But once we do put rules and restrictions, what comfort level do we have, whether we call it personal or pseudonymous or something intermediate, because frankly it is in many cases a spectrum of risk. What are the rules we want to take? So if we look at just a couple of the well-known pieces of legislation or agreements, Privacy Shield, for instance, recognizing that key-coded data, right, pseudonymized data often used in the pharma or health world, isn't considered under the previous agreement or on the current Privacy Shield, a transfer of personal data that is subject to the principles. Okay, interesting. Under GDPR, right, the concept of pseudonymizing data captured as personal, but again, subject to more flexible treatment. If I use it in a secondary way, I've got more leeway if I've pseudonymized data, if I'm doing a legitimate interest test. Again, if I've pseudonymized, it's a safeguard. So covered and treated more flexibly. I'll just quickly mention then the Hipaa data, limited data set, where again, recognizing that there are valuable research uses if data is controlled by contracts and not made public, again, although covered by Hipaa, treated much more flexibly. Similarly, under the human subject protection, under the common rule, we've got that flexibility. Under FERPA, again, the definition swept wide, but significant carve-outs to support the kinds of activity that researchers or others might want to do. I'll go quickly through this just to note that when we think about the identification, we've got to consider who are the attackers we care about. Do we care that an employee might have additional information, a person in your class who might know something very much about where you sat or how you took the test? Or do we trust that those people are not threats? So who are the attackers? Is it the general public because the data is made public? Is it business partners? Are we worried about actual identity or simply learning more about somebody who is already identified? Can we trust legal and administrative controls? If I come to this from a mathematical and scientific point of view, well, there'll be a data breach, or I don't trust companies or researchers or organizations. If I've proven that this can be done, if someone showed I can hack a voting machine, wow, we care about it, even though there may be other protections around it. Or what place do we put legal or other barriers that might make it unreasonable for the additional data sets to be available? They're not publicly available. They're not widely available. They're protected. They're limited. Very quickly, two of the concepts that are increasingly valuable and interesting. Differential privacy, remembering not a technique, but rather a way to measure, understanding that we can't anticipate every future data set that exists. So measuring the effectiveness of releasing statistical data in a way that doesn't create any more likelihood that there is a privacy impact for you, whether you're in this data set or not. I'll skip going through the details on it because of time. And then frankly, again, another area where researchers are increasingly excited using homomorphic encryption, a method of being able to combine fully encrypted data sets, but yet do your calculations and have valid information. Again, useful for some valuable uses and not for others. So just quick final thoughts. Are we talking about public release, in which case clearly we come to it with the set of concerns that we can anticipate every possible method of indirect identifier? We can't anticipate every possible additional data set. And what is our standard? A flag to one of the concerns. We certainly have cities today that are eager for smart city regulation, for other scenarios, to capture data sets, for instance, around location. And those data sets, although the city may feel that they're confident that they're protected, are subject to Freedom of Information Act requests, might be available for law enforcement. And obviously, we've seen risks there. Are we interested in non-public controls where maybe a data trust like Kurata holds the data, where contracts are in place, and do we have a different risk-benefit trade-off or perhaps precision and accuracy trade-off? And obviously, if I'm doing health research, I'm doing other activities, I may want more precision and may be comfortable relying that the controls are in place to support the value. So final slide, since so much of the debate, whether we want it or not, ends up being focused on targeted advertising and behavioral advertising, and we'll talk a little bit about it, I think, during the panel, but let's just look at how this framing of is this a direct or an indirect identifier? Do we have controls or not that we can trust end up being applied, right? So our first assessment is to look at the kind of unique identifiers that are typically in ad tracking data, IP address, cookies, ad IDs, and the like. Are any of these direct identifiers, right? Maybe a name is not in there, but are there lookup databases that are so widely available that we can say, oh, by definition, this is personal because anybody can go and get this information? Or is this a use or is this an identifier that is subject to some restrictions and controls? You can't. There are rules, there are laws. Do you meet perhaps the Breyer test under the European Court of Justice that assessed, is it reasonable that this company is going to manage to get this data? Is it blocked by law? Is it blocked by standards? And then let's switch to the control side. Are there controls in place? And maybe for some uses, we can talk about it, there may not be, but other methods of collection with other controls, maybe there are ways to bound it, probably in the bucket of how do we want to treat pseudonymized data.
Great, thank you, Jules. So you had mentioned GDPR's anonymization requirements. Aoife, can you tell us about Kurata and its approach to de-identification and GDPR compliance?
Good morning, everybody. It's a real pleasure and privilege to be here today, and really looking forward to the opportunity to share with you a little bit about Kurata and its story to date. We're a young company. We've only incorporated, oh, I've gone backwards, have I? Probably go forward. There we go. So Kurata was incorporated in Dublin, Ireland, just over a year ago, and our investors are MasterCard, IBM, and C3 IoT. And privacy and preserving privacy of the consumer is at the heart of what we do, and it's in our DNA. But at the same time, what we're looking to do is to allow innovation to happen and to allow companies to derive data insights and to innovate, but not at the expense of privacy. Although a young company, we were recognized last year by our peers, and we were awarded the Innovation Privacy by the International Association of Privacy Professionals, the IAPP. So, what was the genesis of Kurata? Well, anybody who was looking ahead and looking at the GDPR in draft could see that to do analytics under the GDPR was going to prove to be challenging. One of the reasons for that is some of the foundational principles of the GDPR are around purpose limitation, data minimization, and data retention, all of which make it very challenging to collect data for analytic purposes, because for analytics, you want a large volume of data and you want historical data, and that runs counter to these principles like purpose limitation. Also, typically when you do analytics, it's a secondary use, so it requires repurposing the data. And under the GDPR, that requires a new lawful basis. And although there are a number of different lawful bases under the GDPR, very often consent is one that is relied upon for analytics. But the GDPR raised the threshold for obtaining consent, valid consent under the GDPR, because it requires that the consent, or you prove that the consent was freely given in forms specific and unambiguous. And that can be really challenging to do when you're trying to do data analytics. Also, when you look at trying to do analytics, many companies have decided, rather than trying to rely on consent, that they would look to anonymize the data for the purposes of conducting analytics. But again, the GDPR raised the bar and made it more difficult for companies to do anonymization, particularly where they were trying to do anonymization in-house. So the challenge with doing anonymization in-house is that if you have the original data set and then you create a copy or an extract, the regulators collectively in Europe and also individual regulators have said that the risk of re-identification will remain because you have the original data set and the extract de-identified data set in one house. So that was the business challenge. And so what was the solution? Well, the solution that was seen and was seen as not available on the market was to allow a third party to independently anonymize the data. And that was really the catalyst which brought about the creation of Kurata. So we talked about some of the safeguards. When the Kurata was being designed, we really started with a blank sheet of paper. How do we create a company that's going to operate independently and is going to be able to anonymize the data but to retain utility? How can we design and architect a company that will ensure that we identify the risks of re-identification and then build in safeguards into the company to ensure that every step along the way we ensure that the risk of re-identification are identified and mitigated and that we can operate independently? So we actually went a step further, and under Irish law, Kurata is a trust, not to be confused with a data vault or a data trust itself. Its corporate structure is a trust. This means that there is a trust deed that governs how we operate. We have 3 independent directors on the board whose job is to ensure that we adhere to the trust deed. That deed ensures that no single shareholder can have a majority shareholding to ensure that we operate independently. So that's one of the structures that ensures we can operate independently. In addition to that, it's important to note that we operate as a controller. So we take the responsibility for actually anonymizing the data. And under the GDPR, if we were just a service provider or a vendor, we would be seen as a processor and therefore acting under the instructions of the controller, and that wouldn't be sufficient to underpin this concept of independent anonymization. In addition, then, we have organizational controls in place. Everything from security by design, privacy by design, and privacy by default have been embedded into the organization in terms of the design and also the operation of the company. And finally, the technology platform itself. We have state-of-the-art technology platform. We rely on IBM, but also in terms of what the data scientists do to conduct the anonymization techniques. And I'll just talk about that for a moment. So on this slide, you'll see it effectively demonstrates the data journey that the data takes. So in the very first instance, we in Kurata sit with the customer and we really get to know the data that they hold, the sensitivity of the data, but also the use cases and what it is that the customer wants to do with the data. Once we understand the data, we also understand the direct identifiers and the indirect identifiers. And what we ask the customer to do is to tokenize those and add a solve phrase. The customer then transfers the data securely to Kurata. And once they've done that, they delete the extract of the data set that they've sent us. We then doubly de-identify the data by also carrying out tokenization and by also a salt phrase. And at that point, we also delete the extract. And this is an important point to mention in the journey because at this stage, we've broken the linkability back to the original data set. The customer still holds the original data set, but now the data that we hold, we've broken the link back to the original data set. So at this point now, the data continues on its data journey. And this is where the data scientists now start with test-driven anonymization, where they start carrying out a battery of tests on the data to try to identify quasi-identifiers. They're looking at motivator-intruder tests. They're looking at all the vulnerabilities, what observable features there might be to this data, where might the risks of re-identification lie. At the same time, they're also looking to maintain some data utility. So that's the balance. We have to achieve anonymization, but we are doing so in a way that will retain data utility. Once we're satisfied, the privacy team and the data scientist teams, that we've achieved a level of anonymization, the data then carries down through into a data store. It's important to note at this point, we don't commingle data. The data belongs to the customer, and we are providing analytics back to that customer. So it's not an aggregation, it's not a vault, we don't commingle other customers' data. So at this point, we carry out analytics on the data. and this depends on the use case of what it is the customer needs. Important to note that before anything leaves Truata, we carry out further testing. At this stage, it could be differential privacy testing, where we add further noise as well to the data. All of the time, we're trying to identify and ensure that there's no singling out, linkability, or inferences. These are the tests that were set out by the Article 29 Working Party opinion. The data then leaves the data which leaves Truata is only ever going to be in aggregate form. So it's important to note that, or it could be model code. And that's what leaves Truata, and the customer then receives that and then can use that for its own business to improve, to innovate its products, its services, perhaps for customer segmentation, for marketing on its own consented database. So we are agnostic in terms of the sectors we work with, the various industries we work with, and the various use cases that a customer might want to use the data for. So final slide, in terms of achieving anonymization, Truata has been specifically formed with a view to achieving independent anonymization whilst also retaining utility for the customer. Achieving true anonymization that preserves privacy is highly complex and difficult to achieve, and it requires real expertise on the side of both the privacy side but also on the data scientist side. Anonymization can assist companies to act responsibly and ethically, and particularly to try and rebuild trust with their consumers. So I'll leave it there. Thank you.
Great, thank you very much. So with GDPR, we see one approach to personal data and to anonymization. On the legislative front in the US, it's an open question about how we should be thinking about what is personal data, what is sensitive personal data, and what role de-identification should play. Michelle, I know you have thought a lot about these issues, and that in its proposed legislation, CDT has tackled some of these issues head on. Could you tell us a little bit about that approach to legislation and why CDT has taken that approach?
Sure, thank you. You could find our draft bill at cdt.org. We started last year and convened academics, nonprofits, and some of our corporate partners to see if we could draft our own federal privacy bill. And we had a few goals. One was to create a single regulation that would apply to everyone, that it would be clear and easily enforceable, but most importantly, that it would shift the burden from consumers onto the people who are collecting, using, and sharing data. And we borrowed from the FTC when we came up with our definition of covered data, and we do agree that the test should be linkable or reasonably linkable to a person or a device. We did avoid some commonly suggested categorical exceptions, like de-identified information or publicly available information, and we did that for a few reasons. One, we want this to be a really holistic look at data use. If we are going to do this once, probably right, and set the parameters, we want this to be broader than we've thought about privacy in the US in the past, where it's really more of a consent model. And so that means looking at data use beyond the individual and harms beyond whether a single individual can be tied to data that has some harm in their lives. We want to preserve flexibility for the future. If data processing continues at its current pace, de-identification may become harder and harder to do effectively. And we want de-identification to be encouraged, but not necessarily a get-out-of-jail-free card. It is quite a big deal to take yourself completely out of regulation, especially if we are talking as part of legislation that is going to be the sole way to enforce against data practices, both at the state and the federal level. Being beyond that sort of regulation is a serious, serious consequence and should be very rarely granted. And besides, there are some issues that were back in the 2012 definition of de-identification that I think are now common and actually will be applied across the board. For example, the way we think about responsibility for third-party access to data and what's a reasonable effort to make sure that the privacy promises you give your consumers carry on to your third parties and service providers. We did make a list of sensitive information. I know we're going to talk about that later, but we really tried to keep it narrow and talk about a few fundamental rights, things that are outside of the consent model, things that cannot be signed away. And they are, One, access correction and deletion. I know this is something you're talking about tomorrow. Data security, limitation on secondary uses of sensitive information, and rulemaking to deter behavior that could lead to illegal discrimination, including big data processing, profiling, and the use of automated decision-making. And these are the types of issues that cross-cut in many ways, even if the information is de-identified. So for example, if part of your de-identification tactics are not releasing it publicly, but keeping it in a sandbox and having tight controls, you would want data security for that information, right? So you could actually enforce your de-identification tactics. And I think we understand that de-identification is going to be a big part of the debate once legislation gets moving this year. And we would encourage Congress to avoid granting a get-out-of-jail-free card, especially for things like pseudonymous data. Processing is becoming more sophisticated, and it's going to be much easier to re-identify this information and make really high-stakes decisions about people.
Great. Thanks, Michelle. So I'd like to switch gears and turn now to a specific type of sensitive data, and that's health data. Devin, can you tell us about Citizen and its approach to health data and de-identification? And also, given your long history with health information from working at HHS, is there anything else about Hipaa that you think should inform our discussion?
Sure. Thank you, Cora. Citizen is a new company. We are only about 1.5 years old and not yet available to the public, although we do have about 50 beta users of the platform. We're building a platform that enables individuals to be able to gather all their health information from all the places where they've been seen, and to have that data then be under their control and able to be used by them and then also shared by them. We're starting with cancer patients for lots of reasons. One big reason is because those are among the most motivated patients to actually have their data and need it to seek second, third, fourth, and fifth opinions, to be able to determine eligibility for clinical trials, and then ultimately to be able to have that data used for research purposes so that what they're going through is not, that they can essentially donate their data so that the people coming behind them have a better chance. In terms of what we will do about de-identification, it's actually, we're fortunate to be a young company when all of these discussions are taking place, because we can learn a lot from what has been done in the past. But because we're really designing a platform where we will have relationships with individuals and want to gather their trust, I think for a lot of people, they sort of no longer trust that there's a line between identifiable data and de-identified data, and they want to have some control even over de-identified data as well. So whatever techniques that we will use to de-identify data, which we will because we want to provide our users with options about sharing de-identified data, and we want to be able to, when we present that option to them, to tell them your data has been de-identified in accordance with some ideally sort of standard that is out there and measurable, but also letting them know that de-identification does not reduce risk to zero, that there still is some risk that that data could be re-identified, and are they still comfortable making their data available for that purpose. So in many respects, treating it a lot like the law requires identifiable data to be treated, but yet on the identifiable data level, we want to give people a lot more granularity with respect to their uses and disclosures of data in that regard, whether that's through categories of uses, differentiating between services that might be something they want to take advantage of as individuals versus services where there's data and they want to be able to allow their data to be used for certain purposes along with other cancer patients' data on the platform. So lots of things to think about, but we're certainly going to be treating de-identified data as though it does raise some residual risk, and because it does, and giving people some choices with respect to how they share that. I get asked a lot, what's the business model if you're not, in fact, going to de-identify the data and sell it as a way to support the platform? And ultimately, we want to empower our users to be able to monetize their data if they want to, and we will take some cut from that as essentially a broker's fee of putting patients who have valuable data together with people who want that data. And that data doesn't have to be de-identified necessarily in order to create that monetization opportunity. In fact, a lot of times for a cancer patient, what is valuable is the identifiable data. But obviously, it's a challenge to make that clear to folks because these issues can be quite complicated. But that is our plan for moving forward, is to give people choices, even with respect to de-identified data, and then also to be very transparent with them about what it means for data to be de-identified in terms of the risk. I thought Jules did a great job around talking about Hipaa, and particularly emphasizing that the re-identification techniques that LaTanya Sweeney used of Governor Weld's data were done before Hipaa's standard on the safe harbor was established. But having said that, HIPAA it has in some respects stood the test of time with respect to, health data that is generated in the traditional healthcare system, traditional actors in healthcare in the United States, doctors, hospitals, health plans, pharmacies, not pharmaceutical companies because they're not covered. Nevertheless, it's a standard that was created in 2000. And even at the time that it was created, the agency, the Department of Health and Human Services, got a lot of questions about whether they should whether they should decline to regulate data that were de-identified. And it's kind of amazing, actually, some of the preamble language around the promulgation of that very first privacy rule, where they came up with the two methodologies for de-identifying data. And again, the department was specifically asked, there is no zero risk, and they absolutely acknowledged it. Even at the time, this was in early 2000s, way before we had the amount of data that we have out in the world today that can be used to re-identify. The department was challenged in that regard, and they deliberately made a policy choice that HIPAA envisions a reasonable balance between the risk of identification and the usefulness of the information. So they consequently created two ways to de-identify, created a legal standard around de-identification, which is either not identifiable or no reasonable basis to believe the data can be identified to a particular person. And then they, again, two methodologies: safe harbor, take out 18 specific identifiers and have no actual knowledge that the data set can be re-identified, and you are home free. The regulations disappear. And because HIPAA then doesn't regulate that data, it will be subject to potentially additional regulation by the Federal Trade Commission, for example, if their jurisdiction applies in that particular context. But again, the data has at least been de-identified in accordance with one standard. And then the other methodology is expert or statistical methodology, where the application of statistical methods reduces the risk to very small, never was zero, never ever was zero. But once you have reached that reduced risk of very small, essentially, again, your data are de-identified and they fall out of the protections of HIPAA altogether. Jules mentioned in his presentation what a type of data set called a limited data set under HIPAA, which is, I used to call it the close cousin to de-identified data because it has a safe harbor-like approach. 16 categories of identifiers need to be removed as opposed to 18. There are just two